Have you ever wondered about the boundaries of your privacy, especially when it comes to official searches? It is a fundamental aspect of living in a free society, understanding when authorities can act without prior judicial approval. Warrantless searches remain reasonable when they fall under specific, well-defined exceptions to the Fourth Amendment's warrant requirement, even without a judge's order. These exceptions are balanced against an individual's right to privacy, ensuring that such searches are still conducted fairly and justifiably. The Fourth Amendment protects people from unreasonable searches and seizures, generally requiring a warrant based on probable cause. However, the Supreme Court has recognized several key situations where obtaining a warrant is impractical or unnecessary, yet the search remains reasonable. These include situations where there are exigent circumstances, meaning an emergency requiring immediate action to prevent harm or the destruction of evidence. Another common exception is the plain view doctrine, which allows officers to seize evidence that is readily visible and clearly contraband or evidence of a crime, as long as they are lawfully in the viewing area. Consent is another big one. If an individual freely and voluntarily agrees to a search, no warrant is needed. Additionally, searches incident to a lawful arrest allow officers to search the person arrested and the area within their immediate control to ensure safety and prevent evidence tampering. The automobile exception also permits warrantless searches of vehicles if there is probable cause to believe they contain evidence of a crime, due to their inherent mobility. Finally, a stop and frisk, also known as a Terry stop, allows officers to briefly detain and pat down a person for weapons if they have reasonable suspicion that the person is involved in criminal activity and is armed and dangerous. For you, understanding these exceptions means recognizing when a warrantless search might be permissible. If an officer asks for your consent, you always have the right to refuse, though refusing might not prevent a search if another exception applies. If you find yourself in a situation involving a warrantless search, calmly noting the circumstances and asserting your rights without obstruction is crucial. Remember, the key is whether the situation genuinely fits one of these narrowly defined exceptions, ensuring the search is reasonable. These exceptions are not loopholes, but carefully considered legal principles designed to balance individual liberty with the needs of law enforcement. Knowing terms like exigent circumstances, plain view, and Terry stop empowers you with a deeper understanding of constitutional safeguards. For instance, the automobile exception stems from the idea that vehicles can quickly move evidence, justifying immediate action that differs from searching a stationary home. Ultimately, the reasonableness of a warrantless search always hinges on the specific facts and circumstances. By grasping these specific exceptions and their underlying rationale, you are better equipped to understand the bounds of police authority and your own constitutional protections, fostering a more informed and engaged citizenry. This knowledge helps uphold the spirit of the Fourth Amendment in everyday interactions.